Today on the Pro-Life Podcast, meet the woman who could convince the state of New York that preborn babies are people. We need to talk about this. Let's get started. Happy Thursday, Pro-Life family. Welcome to the table. I don't have my coffee because I'm not Brent, but we have some friends here. Will you introduce yourself?
Yes, my name is Michaela Vaughn, and I'm the Director of Education here at Texas Right to Life.
And I'm Kim Schwartz, Director of Media and Communication, and we have a special guest today. Who are you?
My name is Teresa Collett. I'm a law professor up in Minnesota, and I direct the Pro-Life Center at the University of St. Thomas Law School there.
You have a very impressive resume, and we're going to get into it. But first, I want to know, how did you come to your pro-life beliefs?
I think I always believed that which was within the woman was a child. I think I was not particularly active on it until during college, and it became apparent to me that the idea of feminism, which I consider myself to be a papal feminist, St. John Paul, the great feminist, meaning I think men and women are different, but I think women have tremendous gifts and talents that the community benefits when we are in a position to actually share them. And so it just struck me that this whole idea that abortion was necessary for women to fully participate in the community was just absurd and frankly counterproductive.
Yeah, I mean, that seems pretty reasonable to me.
And what inspired you to be like the pro-life lawyer?
We each have our own individual calling, and we are given particular gifts and talents. And frankly, before I became a law professor, I was in a large firm in Oklahoma. I did elder law and estates and trusts. So certainly the euthanasia fight or the assisted suicide fight was something that I was aware of and frankly was involved in to some degree, particularly with our elderly clients. When I got my tenure track position at South Texas College of Law down in Houston, my first law review article was related to this issue. And I remember there were some of my colleagues who were already tenured and who were senior explaining to me that, no, you don't want to write on this issue because, there will be people who will hold it against you when it comes up for a tenure vote. And I said, well, if I can't survive that, we'll figure it out then.
Exactly.
And so, and we did. And I got tenure a year early.
Hey, God provides. God provides. He's the real boss.
He is. He is indeed.
Hot take. Did you expect, whenever you got into pro-life work, did you expect that we would overturn Roe in your lifetime?
Absolutely not.
Yeah?
Absolutely not. I would say to my students, you're the ones that are going to overturn Roe. Mm-hmm. If like Solomon, which I bear no resemblance to, but if like Solomon, I were asked, what is your heart's desire? It would have been, I want to be the lawyer that overturns Roe. I don't want to be the fifth justice. I want to be the lawyer that makes the argument that wins. My friend in Mississippi got that privilege, and that's wonderful. But I'm somewhat optimistic about a case we have in the Second Circuit, perhaps having a huge impact as well. We'll see. We'll see. So
that's got to feel good to be the lawyer who won the argument to overturn Roe, like your name like written in history there. But obviously there were a lot of steps to get there. But whenever I was thinking about, this interview and what we'd talk about, it came to mind that a lot of people think overturning Roe is the same as saying that preborn children have personhood, that their rights are protected in the Constitution. But the case that overturned Roe, Dobbs v. Jackson, Dobbs just said there is no right to an abortion, period. Abortion is not in the Constitution, period. That doesn't mean that that they're saying that preborn children are human just like you or me. So saying that abortion is not in the Constitution is not the same as saying preborn children have the right to life. What would it mean to be there, to get there, and what would it take to get there?
Dobbs said that abortion is not in the federal constitution.
True. Yes.
Right? And therefore, it was not a matter for federal courts. It was a matter for state courts and for state legislatures and the body politic. There is a debate because in Roe versus Wade, the court affirmatively held that unborn children were not constitutional persons. And I believe that Dobbs reversed that holding. But there are very talented, very experienced pro-life lawyers who disagree with me on that. They argue that because the way the Dobbs court overruled Roe and Casey, it was not necessary for them to reach the personhood question, and therefore that opinion does not reverse the Roe holding. Now, I think they're wrong, and I think they're wrong for a couple of reasons. When the United States Supreme Court overrules prior cases, they can do it in one of two ways. They can either do it in toto, which says essentially we're wiping that case off the books. The case was grievously wrong, and we're uprooting it root and branch, right? It can also do a partial reversal because Chief Justice Roberts' take in the Dobbs case was, let's not be radical here. Let's just answer the question before us. The question before us is, can states limit pre-viability abortions? And that's all we need to answer. We don't need to go a bit further than that. We can just answer that narrow question and leave for another day the rest of the questions that entails. And Justice Alito, writing for the majority, said, we are not going to kick the can down the road. No, we're not going to do that. Let's get her done now. And so I believe that the majority opinion is very clear that they are reversing Roe completely, including that personhood ruling. But again, as I said, there are some very bright lawyers that do not share my view.
So how do we get an answer to that then, whether the court in Dobbs said that even the idea that preborn children don't have the right to life, that was overturned with Dobbs? How do we get to the court to say, yeah, this is what we meant?
We need to put that at issue in front of some sort of federal district court. That's the more likely way to do it rather than going up through the state courts. Sometimes you can get something up through a state Supreme Court, but that's incredibly rare. And in fact, I have a colleague in New York, and she and I have a case in the Northern District. The trial court decided that we don't have a case. He dismissed us. But we are in the Second Circuit arguing that the trial court was incorrect in not letting us into court. We represent two women who were physically assaulted during their final trimester pregnancy. One had a chair thrown at her. Another was thrown down the stairs by their sexual partners. And so they are representing women who have been subjected to coercion and physical attack during the post-viability phase of their pregnancy. We filed this pre-Dobbs. And we also have a plaintiff where the mother was expecting a baby that we called baby Nicholas. And so baby Nicholas was in utero more than 6 months in gestation, viable. And she had actually a restraining order against her former sexual partner because he had threatened to burn the house down and kill both her parents and she and the baby. The lawsuit is about when the state of New York passed its Women's Reproductive Health Act. They amended the state homicide statute, which for over 100 years had included viable unborn children in the protection of the homicide statute. Basically, it was a feticide statute.
Yeah.
And they repealed that. And so we were arguing that these women who had been victims of acts of violence were being deprived of the protection of the law that they were entitled to And then baby Nicholas would be our class representative, arguing that he also was being deprived of protection, and that because he was being denied equal protection because a child at 24 weeks outside the womb would be protected by the law, but a child within the womb would not. And so the district court found that in this instance, we had not established that the mother was entitled to represent baby Nicholas. Now, that is, I think, clear error. That's part of the reason we're in the Second Circuit.
Yeah.
Parents are always the natural guardian of their children.
If not who, right?
Yeah, exactly.
Absent some showing of misconduct.
Right.
And we had both the mother and the grandmother seeking to be appointed as actually the phrase is next friend. If you're on the plaintiff's side, you're the next friend. If you're on the defendant's side, you're the guardian. And it was very interesting because his order also contained a footnote saying, I am not addressing the personhood question that's been presented.
Classic.
And so, but I think that is such a clear error because the reason he dismissed the case is, well, there's nobody to argue for baby Nicholas. Well, yes, Your Honor, if you won't let...
Hey, who am I?
And if you won't let the mother argue or the grandmother argue or his lawyers argue...
I don't know.
You are quite right. There is no one to argue for it because you are denying us the opportunity to represent him.
Big brain move.
Yeah.
Classic.
So if we are successful,
Yeah.
the oral argument was last March. If we are successful, we will be sent back to the trial court. And as one of the 3 judge panel said toward the end of an argument that went twice as long as they had allocated time for, well, I think if we send it back, who knows what we'll learn about viable unborn children. And I thought, okay, I'm done. Thank you. My work here is done. So I am guardedly optimistic that we will have that judge's vote.
Yes.
We need 2 out of 3, and we'll see. Now, the other interesting thing about this is it could be argued that if we win and get sent back to the trial court, because we're just at the very beginning, notwithstanding that this is more than 3 years old as a case, we're just at the very beginnings. There is a First Circuit opinion dealing with Connecticut where the court refused to address the personhood question and said that it was not something appropriate for the court to consider. Now, the problem is that ruling came down like 3 months before Dobbs. If I recall, actually the pirated copy was out on the street, right? So the First Circuit knew what was coming, but they relied on Roe to say the Supreme Court's decided this.
Okay.
So it's not a clean conflict between the circuits. So that'll be a tactical decision we'll have to make at that point. But if we win and we've got this Second Circuit, in theory, we could have the circuit split, which is not required by the Supreme Court, but often moves the Supreme Court
Definitely.
to accept the case. We are arguing a very simple argument that the right to abortion is the right to be free of an unwanted pregnancy, not a right to kill. And that what the Dobbs opinion says, and I see the limitations in what we will achieve if we achieve it, but what the Dobbs opinion said in our view was simply that because states are free to recognize, as they do in Minnesota, a woman's right to terminate her pregnancy prior to natural birth, and because they're equally free, as Texas does, Idaho does, that a child has a right to continue its development in its natural environment, that you have what Larry Tribe would call a clash of absolutes. You have the woman's right that is in direct conflict with the child's right, at least up until viability. And so we read the Dobbs case as saying the U.S. Supreme Court, the U.S. Constitution simply does not tell us which one is paramount. But if we argue that at the moment the child becomes viable, what is not a right to terminate a pregnancy or be free, it becomes a right to kill. And that there is no precedent from the 1600s forward for a private right to kill. And therefore, the state can continue to allow a woman to terminate her pregnancy at 24, 25, 26 weeks. But they cannot allow the direct and intentional killing, which is, of course, the object of the dismemberment abortion procedure, the saline abortion procedure, which they're still doing in New York, which is
It's insane.
wildly unsafe, or any of the other techniques they use at that stage of the pregnancy. So in other words, the woman will have a choice of either continuing her pregnancy to its natural termination, or she can deliver early and using the safe haven law, which New York has. Just Texas, of course, originated safe haven laws, but the woman can then, invoke the safe haven law and walk away, and she is free of, as Justice Amy Coney Barrett noted in the Dobbs oral argument, she has no obligation to nurture or parent that child. So it's a interesting, fascinating case. Could have tremendous consequences. I recognize that post-viability abortions are a small fraction, but I'm also a big believer in you're walking by the side of the sea and you throw a starfish in and somebody says you can't save them all, to which your answer is, it mattered to that one. So,
Definitely. That kind of leads me to the next question is, why did you choose viability for this lawsuit to prove personhood and establish personhood in the court, hoping to ban abortions nationwide after viability? Why didn't you go for like the whole starfish, for example?
well, the population of starfish, right?
Yes.
In this instance, number one, we filed the suit under the Roe Casey regime. It was before Dobbs. It was filed pre-Dobbs. So that's the first best answer to that question. Cool. But also, given especially Chief Justice Roberts, and Gorsuch often follows Roberts, his separate opinion in Dobbs was troubling. But he voted the right way. So
he did.
Good for you, Justice Gorsuch. But we think that there is such significant public sentiment for that the political firestorm is going to be very different. And third, it's consistent with history and tradition, which of course is something that the court invoked to overturn Roe, that even the pro-abortion folks admit that the common law made it a capital crime to kill a baby after the woman could feel movement, after she became quick with child. And in this instance, viability is even later than that. So we are well within the history and tradition. We are well within the statutes that existed with the passage of the 14th Amendment within the United States. And so we passed the test that the court used in Dobbs to show that, Roe v. Wade's history was completely made up by an abortion advocate. And the court basically dismisses it with a simple sit, saying something to the effect of, they either ignored or misrepresented it, which is a very harsh statement for a prior Supreme Court.
Yeah. Man, but I'm excited. So we're going on the offense here.
We will see. Well, of course, Texas are the masters of that. The civil liability is a brilliant move, I've got to say.
Thank you.
And I greatly admire that strategy.
Okay, well, we're going to take a break, and you're going to want to come back after the break, because afterward, we're going to talk about artificial wombs. It's not a sci-fi pipe dream. It's, it's on its way. So we will come back right after this.
Do you have a cell phone? Do you have pro-life values? Do you like saving money? Well, Patriot Mobile is America's only Christian conservative wireless provider, and they've partnered with Texas Right to Life. So if you'll go to patriotmobile.com/Texas Right to Life or call 972-PATRIOT, 972-PATRIOT, and use the checkout code TRTL, they'll give you a free month of service. So make the switch today. Have your money support causes you believe in, and save and get a whole free month. Make the switch right now. What are you doing still watching this? Make the switch right now.
Want to support a cause you love and look great doing it?
Visit the Texas Right to Life online store. You'll find t-shirts, hats, mugs, bags, everything you need to rep the pro-life movement wherever you go. Plus, you'll get free shipping on every order. Listeners like you, yes, you, can get 15% off when you use code PODCAST at checkout. Visit store.texasrighttolife.com today to shop with purpose and make a difference.
Welcome back. Artificial wombs? What's going on with them, and why is it in the news lately?
Well, frankly, there have been two companies or two medical research groups, they would be offended to call them companies, that have filed requests with the FDA to start human trials for artificial wombs. The one that seems most, or perhaps it's just because I don't have an adequate medical background, the one that seems to me the most viable, no pun intended, but is the biobag, where their clinical trials have involved lambs, which has similar dimensions, similar physiological characteristics of a human unborn child. And they have been able to gestate those lambs within the biobag. These lambs apparently retain normal characteristics, both in maturation, in reproductive capacity, in their behavior. And so it's a really interesting possibility. And essentially what you do is you create, it looks like to me, those big bags you can buy at Target or at Walmart when you're packing your winter clothes away and you suck out the air. Exactly. It looks like something like that, but it's filled with a substitute amniotic fluid, and it's connected by a mechanical device that will essentially attach and act as the umbilical cord with the blood flow and the removal of waste for the child. And the way, in order to place the lamb in the biobag, they perform essentially a C-section, cesarean section. They connect up the feed so that the lamb can have the necessary oxygenation, et cetera, and they place it in the biobag. And they've been very successful. There's a second device that doesn't involve the biobag in the same way, but both proposals are before the FDA. And last year, late in the year, the FDA actually had a special meeting of their pediatric research committee to evaluate whether or not an application for human trials should be accepted and what the criteria for evaluating such an application would be.
I have a question. For the lamb test, did they gestate the lamb from like zygote all the way through, or okay?
No. In that instance, frankly, you wouldn't have to do a cesarean. Right?
Yeah, that's what I was thinking until you got to the C-section part, and I was like, okay, this is an older lamb, but at one point,
it is an older lamb, and they're trying to what the initial goal is to be able to gestate an infant from 18 weeks gestation forward, because right now it's 21. I think there's a couple of recorded cases of 20, but and part of the ambiguity and one of the other difficulties in our case in New York is the definition of viability itself, separate and independent of sort of a calendar date. Because in Dobbs, the court said, look, viability is problematic because it's sort of a moving target. And not only is it a moving target, but it is tremendously based on facts and circumstances. There are no neonate wards in certain parts of rural Texas, for sure. I mean, the abortion industry complains about, abortion deserts. Well, there are neonate deserts that are much larger.
That's so important because, when looking at viability, and I understand the importance of arguing viability from the legal perspective, but when we're having conversations with college students on campuses, when we get to the point where someone might be saying, okay, well, I think viability is when
it's a real person.
Abortion when it's a real person.
Yeah.
So does this mean that if we're at a rural area in Texas, a baby is born at 24 weeks, does that baby not have the personhood or the value of the same baby born in Houston's Med Center at 24 weeks? One baby can survive, has top of the line care, and then the other baby born in rural Texas, does that baby die? And then we're looking at, a classist system.
Because ultimately the viability argument says your value isn't intrinsic. It's not something inside of you. It's something outside of you on our ability to take care of you or not. And so, that's why viability for a personhood, like entire personhood argument, like if you believe that life really does begin at viability, you're saying that the person's value is not intrinsic. But with these artificial wombs, we're going to talk about the pros and cons of them here in a second. But the FDA is asking, what are the circumstances that we would use this? How early or late in pregnancy can we put a child in this artificial womb? Because the human trials the lamb trials hadn't successfully done this from like zygote all the way through. So it seems like this would kind of be like an emergency provision and not just like, I don't really want to be pregnant, I hear it's hard, so I'm just going to like gestate the baby in the artificial womb rather than, my body is that.
Or employers, we can't afford to let you off for that long, so we'll pay for the artificial womb, and we'll pay for IVF, we'll pay for implantation, and now, of course,
I can see them doing that, and that is so cringy.
It is.
Yes, that's what I was thinking of. Like, would an employer discriminate against a family who couldn't afford the artificial womb because, that woman's not going to be as good of a worker as a woman from a higher upper middle class who can afford the artificial womb?
The team player who puts her baby in the artificial womb just because she's doing her job. Anyways, okay, keep going. I'm sorry.
Well, before we get to the pros and cons and into like this segue, I want to first mention this isn't, like you mentioned, sci-fi anymore.
Right.
It's not far off. In the discussions, we're looking at human trials starting when?
Maximum probably 8 years.
Maximum.
So, this isn't just something that's going to, be for the next generation. This is happening in the 2030s.
Yeah.
Okay.
That's wild. Oh my gosh. Okay, so then how should pro-lifers look at the artificial womb? Because I think in some ways you can say like, oh, this would be a good thing. We're going to help babies who are born like super premature. But science tends to have this ability, this knack for taking a good tool and turning it into something really awful. So what are the pros and cons of artificial wombs?
Well, human wisdom and prudence should always guide any of these decisions. I don't think it's inherent in technology, although in culture there sometimes is a scientific imperative. If we can do it, we must do it, and that's simply false. And before the atomic bomb is a clear example of that. And so there are lots of things to think about. It's difficult, though, to contemplate the sort of life-saving capacity that it has for those children that are, because of preeclampsia, because of other some sort of problem, that we would not want to maximize the ability of that child to develop. And one of the hopes, I think, of some of these medical researchers is that the artificial womb, unlike the neonate ward where the child is in an external environment, and yes, you can put them in the tent so that the oxygenation of the air so that the lungs can develop and those sorts of things. But one of the beliefs is that this could actually minimize the sort of disabilities that are often attendant to a premature birth, where the child is put in a successful neonate ward. And so I see the attraction to it. I see the sort of fears that are real. But again, at this point in time, we're not talking about gestating from, the frozen embryo. And frankly, that's a separate pro-life problem, right? We're not talking about the capacity of that. We're talking about a intervention that is designed to primarily address what do we do with these children that through the woman's physical health simply cannot continue to term and I think they are hoping to push it back to 18 weeks or something. So we've wandered a long way, but the artificial womb is not going to, at least not for an extended period of time, be an answer to the IVF problem. It will pose its own dilemmas, as we've begun to allude to, the idea that there will be employers, like there are employers today, that will pay for women to go get abortions and give them time off, and that will pay for women to freeze their eggs, that will pay for women to engage in IVF because they don't want them to be distracted from their job. So we're going to see that, no doubt. The other question that we're going to see is once the child is external to the woman's body, let's say that as the child develops, not because of any fault in the biobag, but because of some genetic predisposition, the child clearly begins to develop some disabilities. And the parents want to direct the care provider to disconnect the biobag.
I don't like that.
Well, you're really not going to like it when the question arises, are we going to follow the old Casey versus Planned Parenthood rule, which the woman unilaterally can direct the disconnecting of the biobag?
Right. So if a father wants to keep the baby alive, the mother could on her own choose to unplug or whatever it is.
That was the ruling in Casey versus Planned Parenthood.
Well, that is a good example of why we need pro-life doctors, pro-life lawyers, pro-life moms and dads, pro-life teachers, all the pro-life things.
Judges.
Yes, judges. And you, Teresa, are a great example of why we need good pro-life lawyers, because you're out there fighting the fight, being on the offense, and keeping people informed about crazy things like artificial wombs. Yeah. So I think that's all we have for today. It's been a ride. We've been all over the place, and I'm still just like, my mind is blown from all of these topics. But I hope you feel informed now. If you enjoyed this video, make sure you like, share, subscribe, comment, all the things, and we will see you in 2 weeks.
And I'll send you an update if we win in the Second Circuit.
Yes.
I may be deafeningly silent if we lose.
We'll keep you posted. See you next time.